right, we're back on the record. Looks like everyone is present, states present, applicant, Mr. Garner, Mr. Udishin, you may proceed.
Thank you, Your Honor. I would first, look at approach.
Of course.
Dr. Glasnick, I want to show you what we've marked for Defendant's Exhibit 9 and Defendant's Exhibit 10. Without saying anything about them, do you recognize those documents?
Yes, I do.
Okay. And let me show this.
Did you call them defendants?
That's how they're marked. What are we calling our exhibits?
Kids, they don't make.
Where did these?
Oh, they don't make an applicant sticker.
That I found.
You can get some if I need to.
All of these have defendants on it. So what we'll do now is just for the record to be clear that all of the previously admitted exhibits, which was 1 through 8, are titled defendants, and those are applicants. And so we'll just use the defendants, keep it the same, knowing that defendants equals applicants.
These pursuant to your subpoena?
Okay. This is his question.
Pursuant to the court orders from, correct.
So this wasn't a part of the state's record at trial?
No, it was not.
Okay. Twofold objection, Judge. I think I know where you're gonna rule on the first one, which is, my running objection, that this was a part of the underlying court record. The second objection is that this is not the appropriate sponsoring witness for these CAT scans from the Texas Children's Hospital, particularly if they weren't, again, a part of the underlying, admitted at the underlying trial.
Is this an authentication issue you're bringing up?
Your Honor,
Or something?
these, if I could address that.
Sure.
So these are the CAT scans that Dr. Glasnick testified about before the lunch break.
But
And they're already, I believe they've already been introduced and accepted as evidence as part of a bigger exhibit, but I'm just pulling out these 2 pages so the court can look at
would
them.
that be number 3, the imaging files from Texas Children's Hospital?
Yes, Your Honor.
And had I known, I would have lodged my objection at that time, Judge.
Well, I mean, the imaging files from Texas Children's.
These are different.
No, no, I'm sorry, these come from that. These are in that exhibit. Am I
That's correct.
right?
They're in that exhibit, but they weren't admitted in the underlying trial. It was obtained subsequently through the court order, as
Okay.
additional records.
8 and 9 are admitted. That's overruled.
Okay, so can I proceed here?
Yes, sir.
Dr. Glasnick, I'll hand you again defendants 8 and 9. First of all, are those the scans you were referring to earlier in your testimony?
Yes, this is the scan. It says up at the upper right, Garner, Kalen, date of birth 12/3, Texas Children's Hospital, date of 2/26/2000 at 4:02 p.m. in the afternoon. And at the upper right corner, you see sequence 2, image 14 of 23, and sequence 3, image 13 of 23.
So you were talking earlier about a right occipital hemorrhage.
Correct.
And I would just like for you to hold them up and show, hopefully the judge can see it from there, but just point to what you're looking at and then I'll hand it up, then I can hand
You're
it.
welcome to use the Elmo and we can switch the TVs where we all are seeing what you're
Okay.
talking about.
Can you figure out?
If you, yeah, so if you switch
Put it under here.
on the Elmo machine itself, Mr. Coleman, would you show where the input button is, please?
Yes, Judge.
Yeah. see what-
Which this right here is something, having Mr. Coleman show how to use the electronics.
Sure, he knows more than me.
He's come a long way.
Why do everybody keep saying?
Because you've come so far, I'm giving you props. Giving you some kudos. There it is.
Thank you.
And I also have that on my screen here.
Okay,
So,
put number 9 up first and we'll let.
and there's a pointer with the green, let's go.
Oh, great.
Severity. And zoom it out.
Yes, you should be able to,
There, that's. Okay, so Dr. Glasnick, can you explain to us what we're looking at here?
Yes, This is a CT scan. It's X-ray technology, means you're using X-ray beam. So the baby is on the table with its feet towards you, facing up. So 9 o'clock is the patient's right, 3 o'clock is the patient's left. On CT scan, bone is white, brain is gray, water is black, and acute blood is whiter than brain. So this is the right posterior occipital area, and that blood is sitting right there. And notice how it kind of almost like mounds into the brain. That makes it epidural as opposed to subdural blood. And this little spot right there is the lambdoidal suture. That's the normal. Babies are born with various skull plates separated by the sutures, and so that looks like this blood. If you look real close, almost seems to track itself down in between those. And I'm not doing very well with my pointer.
And if it's easier, you can do it right behind
Oh,
you.
okay. Oh,
You can look over there.
yeah. This is the brain itself, and normally you would see subarachnoid space with water about 3 millimeters thick, but the brain is so swollen that has all been squished out. You come down here, and this is this mass of epidural blood. It almost seems to separate the two bones right there. This is was not mentioned. I mean, I just overlooked it or forgot to fill the sentence, or the transcriber didn't put it in. But this is clearly here to the right occipital area, and that would be confirming impact to this area, not necessarily a trivial impact to the area.
Okay, and let's show.
Oh, but the brain. Normally, the brain is not this dark. When a brain is not getting enough oxygen, a lot of your energy is involved in keeping water out of the cell. So if you run out of oxygen, water comes in, and water on CT is dark. So this brain here is much darker than it's supposed to be. But this is massive brain edema with this acute blood, epidural blood sitting right there and looking like it goes in between those two bones right there.
Okay, and let's show Defendant's Exhibit 10.
And again, see,
So first of all, so is this is not the exact same scan as before, but it's the same
no,
thing. To
What's
explain
the-
the difference.
what CT does, they're really neat. They put you in this machine and they start shooting X-rays at you from all different angles. And then they just like bologna slices going up, and then they push a button on the machine that flies it like in the sagittal section, and then they can do front to back. So what you're looking at is like a bologna slice, and these slices are I guess is about 5 millimeters. What am I saying? Each slice is 5 millimeters in thickness, so your slice of bologna is 5 millimeters thick, and this is where it is at. You see the date and the time over here, and this is sequence 2, image 14 of 23. So you could ask a radiologist, will you please pull up sequence 2, image 14 and 23, and this image would appear.
And it's the same blood, but it looks a little different.
Oh, yes, because the other one was slice 13. So this is the bologna slice next to it. So that blood is now not seen here, but you see this again, mound of acute blood right over, this is the other side, but this is clearly different, and it's wider than brain. It's not fluid. It is clotted blood up to about, could be up to 10 days old. Obviously, the history implies that it's would not be that old, but the aging of acute blood on a CT scan, if it's wider than brain, it can be 1 to 7 to 10 days old.
Okay, so in this case, I'm going to move on from these scans.
Right.
In this case, they didn't do an MRI, I think.
Correct.
So do you know why not?
Well, MRI you got to have sedated. It takes about 30, 40 minutes. CT scan takes a matter of a few minutes on a terribly sick infant. It may be a bigger deal to do an MRI. Back in 2000, I don't know what the standard was. Certainly by 2010, 2011, MRI, early MRI would be pretty standard.
So today they would do it.
Yeah, I think so.
Okay. Now, there was some testimony from Dr. Stein where he was describing to the jury what the shaking was like, and he gave an example of a tomato in a can. Do you have some comments about that example he gave?
Yes, I think that was an inappropriate example to use, because if you had an egg or a tomato in a glass jar without surrounded by water, you shake it, it's going to bounce all over the place, crush, which is what the jury perceived he was demonstrating by that. But if you took that same jar, totally filled it full of water, and then put the tomato in it, so there's no air in that jar. In other words, much like the intracranial vault, where the brain is surrounded by water, not surrounded by air, and repeated shaking, the brain would not be bouncing off the side. It would not be bouncing around.
So today, do genetic factors or testing for genetic factors have anything to do with these types of evaluations?
Yes, particularly if the issue of you're always screening for easy bleeding, like hemophilia, factor 12, factor 9, and platelet disorders, or people who bleed too easily. But everything in the biological system is kind of like a bell-shaped curve. And you also have the people who clot too easily. That's called thrombophilia, clot loving. And there is a genetic workup. You can be genetically predisposed to easy clotting. These can be people who, young women on birth control pills, have a stroke, or someone who sits on a plane without getting up and walking around for 4 hours can have a clot in their leg, which can break loose. So this is the thrombophilia. So in any case where a venous thrombosis is an issue, there is a standard workup of protein C, protein S, factor 5, Leiden, I think it's Leidem, I don't know for sure, but there's a series of genetic tests that are done to make sure that an individual is not specifically prone to clot.
And they didn't do those back in 2004. Okay, now, in Dr. Stein's testimony, he was asked a question by the defense attorney, and the question was, and in this case, obviously it was a right occipital hemorrhage, correct? And his answer was, it was not a right occipital hemorrhage. Now, what you're showing us on these scans, is that a right occipital hemorrhage?
Yes, it is. It's epidural as opposed to subdural, but it is acute hemorrhage in the right occipital area.
Okay, so when he says it wasn't that, he's just wrong.
I think he's wrong or didn't understand I don't know if he looked at the imaging himself or not.
Okay. Now, I want to shift gears and talk about Dr. Patricia Moore, the state's other medical witness. And you understand Dr. Moore was at the Harris County Medical Examiner's office and did the autopsy, I don't know, 8 months later or so. And so she had, I guess it's fair to say, less information to provide the jury than Dr. Stein did.
Yeah, she would have much less information to provide.
But nevertheless, Dr. Moore testified that these injuries were caused by shaking. You recall that was her testimony, and that she also testified that the only other thing that could cause these injuries besides shaking was a severe motor vehicle accident.
Right.
Okay, now I think you've already told us, but that testimony is incorrect.
Yes, that testimony was incorrect. What she would have had at her disposal 8 months later would be that the brain had shriveled up to the point of about 1/3 its original size, and all that would show would be a terribly damaged, shriveled up brain. So from my background, there would be nothing on that to allow her to say what would happen 2 hours before, 1 hour before, 3 hours after presentation. But what she did have was when they sliced open the eyeballs and looked, there was residual of the of staining where the retinal hemorrhages were. So she would have had, and the testimony I thought I read was evidence of retinal hemorrhaging, which in the thought of the time would be that this is evidence of residual evidence of retinal hemorrhaging, and that would require a requisite component of shaking.
But so even though we now know that's incorrect, at the time in 2004, she was giving testimony consistent with what was believed to be correct.
Correct, and I have to, there was comment about the staining in the eye, which is, I assume, I have to say that's what she was basing her opinion on there. But the brain would be so damaged and scarred at that point in time. I don't know that one could make much of a comment as to what the original event was. The x-rays were read, of course, as hypoxic ischemic injury without enough oxygen getting to the brain.
So you're aware that Dr. Moore, at the time that this writ application was filed, she recanted her testimony where she signed an affidavit saying that she would not testify the same way now based upon what her understanding is of the new science.
I've heard that, Tristan.
Okay, so she's not the only doctor that's given testimony in the past that supports some of the theories of shaken baby syndrome that has later decided they were wrong. I mean, that happens fairly frequently, doesn't it?
Not infrequently, and I think that many, I never testified to the prosecution, but I have colleagues who were testifying that shaking is real, testified for the prosecution, who then have now totally done an about face. Dr. Plunkett said he would volunteer to review any case he had previously said otherwise to on any kind of appeal. So that, yeah, once you realize that things have changed, the ethical thing to do is to admit it and try to not make the same mistake again.
Well, so that's really my final question is just as an expert witness, as a medical professional, as somebody who testifies in court, what are you supposed to do when you realize that your testimony was wrong, because the science has changed or for some other reason? What should you do under those circumstances?
I don't know that I've seen it in writing, but I would think she should be willing to go back and volunteer to be involved in the revisiting of the case. You know, there may be other evidence, but if what your testimony implied is no longer adequate, it would seem appropriate to inform attorneys that a revisiting of the case might be appropriate.
Okay, thank you. I'll pass the witness, Sharon.
Thank you, Mr. Houston. Would you tell me those two, and I'll keep them with this, if anybody
I'll
needs.
switch. Yeah, that was my plan, just.
Here it goes. It just takes it a minute. There should be two. Yeah. Perfect. Thank you.
Good afternoon, Dr. Lavnick. Please, I want to start by apologizing if I get some of these terms incorrect or mispronounce some of these medical terminology at any point. Feel free to correct me, please. Is it your testimony today that you can't shake a baby to the extent that you cause brain injury without there being a broken neck or some type of a fracture of a ligament in the neck?
My testimony today that without doing that kind of thing, that there is no experimental literature to suggest that the abusive shaking would be a primary cause brain injury in a previously normal child.
And-
I hesitate that because if there's,
I'm sorry to interrupt, but
Your
in my word,
Honor,
well,
I'm gonna
I-
object to him interrupting.
well, Judge,
Well, hang
I
on,
asked a
so
yes or no question.
I'm gonna,
Yeah.
obviously, there was some leeway given
Yeah.
with Dr. Glasnick, answering the questions and giving, further explanation. At this point, let's just get whatever the question is, and then if you want to follow up, with some further explanation, we'll get there that way.
You understand, Dr. Glasnick, if there's some elaboration that you'd like to make, with regard to any of the questions that I asked, Mr. Udishin can come back and follow up and give you the opportunity to elaborate. But for now, my question to you is a very pointed question, please, sir. Is it your testimony today that you cannot shake a baby to the extent that that causes a brain injury without there being some fracture of the neck ligaments or some break in the neck? Yes or no?
there is no evidence that that would happen.
Okay, all right. Now, could there be a trauma, a head trauma, an external head trauma, without bruising?
Yes,
Okay. And in this case, you're taking the word of a convicted felon that the trauma that was caused to the head was striking that baby on the door frame. You're taking that and making your opinion, correct? Yes or no?
I am.
Let me ask it a different way. That's part of your calculation, right?
Well, I think I would like to say a little bit of orientation. My job not to prove or disprove abuse. Now, I'm taking the witness statement from the record.
Hold on, don't talk over
Objection.
each other.
Not
I'm-
responsive.
Look, there's gonna have to be some explanation. So if it's, not everything is gonna be bright line, I understand that, and I'll allow some explanation, but try your best, doctor, to just answer what Mr. Coleman's asking.
We're talking about the door frame and the defendant's version that the child, he struck his head on the door frame. You're basing the entire, at least part of your calculation, your conclusion on his representation, correct?
Correct. I start with the history in the chart, and that's what I have to deal with. Is that what comes through?
So that's a yes, Dr. Gillespie, right?
Okay.
Yes, okay. Now, if that were not true, if you weren't taking that at face value, then that would, and it's not true, then that would change your calculation. That would change your conclusion, correct?
No. It changes. It's my conclusion. You want me to say that this is or is not abuse. My conclusion is that is impact there, whether it's accidental, whether it's a door frame, or whether it's inflicted, is not something I am here to decide. You are trying to make me prove it's abuse. or not abuse.
Just answer the question.
I promise I'm not trying to make this typical, Judge. I just want a yes or no answer. Judge, I think I made my point and I'll move on.
Thanks.
You've taken that story. Well, let me ask you this. Are you aware that in fact that story did change? Are you aware that initially this defendant told law enforcement that there was no trauma?
I received the first witness statement and the second witness statement, and that this appeared in the second.
Judge, at some point, I mean,
He answered your
I
question.
know, just this yes or no. Back to the last thing. You weren't there that day on February the 25th of 2000 when this injury was inflicted on Kaylin Garner, were you?
No, it's not.
Thank you, Dr. Lashley. You truly don't know what actually happened on February 25th of 2000, do you?
That's correct.
Is it possible that this defendant could have violently shaken 2-month-old Kaylin Garner that day?
It's possible.
Is it possible that this defendant could have violently shaken Kaylin to the point that he used repetitive motions and done so on a repeated basis?
I I can't say he didn't.
Is it possible?
Yeah, I guess it's possible.
And let's talk a little bit about your, I've read your resume. Let's talk about your clinical experience. Do you have any clinical experience either evaluating firsthand or treating firsthand abusive head trauma in infants?
Uh, Not, no, the last time I was a primary treating physician for small infants was 1980.
But have you had any firsthand, person-to-person experience treating clinical in a clinical setting, either evaluating or diagnosing abusive head trauma in infants?
No,
Okay. You understand that there is a difference between a clinical trial and a case study, correct?
yes.
Please briefly explain to the court your understanding of what a clinical trial is versus a case study.
A clinical trial is my understanding, let's say we've got a brand new drug and we want to try it out. So we said this group gets this drug and this group does not get this drug. So clinically, we give it here and see if we can document a result. A case study is where a case series is where you take a series of cases and analyze them and try to extract some kind of conclusion from them. And so that and in a case study series, there's individual cases. But in a case study series, you have to have inclusion criteria and exclusion criteria. In other words, you have to say what this case has to have embodied in order to have enough information to be included. And if, for example, you're looking at head injury and you want to know what MRI shows, if the baby did not have an MRI, he is not in that series. If he's not in the age range, he's not in that series. So that's a clinical case series.
Thank you, Dr. Galesnik. And would you agree or disagree that a clinical trial that examines a group or a cohort for over an extended period of time is more extensive, more detailed, I would say, than a case study? Would you agree with that?
You use the word clinical trial. We're not experimenting with abusing half and not abusing half. What you're referring to better is a retrospective case series or a prospective case series, where you say that going forward, we're going to take we might treat patients coming in this way versus treating that way.
If you're going to get a case series or a clinical, you know what, you're right, I was referring, clinical trial is the wrong term, a clinical research study.
All right.
That's what I meant to say.
All right.
Would you agree with me that a clinical research study is more in-depth, more extensive than a case study?
It's more extensive than a single case, but you collect your case series, whether you do it retrospectively or prospectively going forward. That would make a bit of a difference. I mean, for example, make clear the classically cited article is the Rook study, where she said, I will do MRIs on 101 successive deliveries. So they take 101 births and do MRIs on birth on every one of them. That is going forward and reporting the results. A retrospective is where you say, we're going to go back and look at the last 100 patients where we diagnosed, let's say, abusive head trauma, and reanalyze those in hindsight. So in looking, and this is very important specifically because what I would like to make is that when you are evaluating literature that is based on even a retrospective case review or going forward case review, they always have to say the range. In other words, we're looking at all the cases of diagnosed with UC head trauma between 2010 and 2015.
And
That is-
Dr. Glasnick, I'm sorry to interrupt you. Was a yes or no question. I can't let him go on, Judge. But you would agree, yes or no, clinical research study is more in depth than a case study,
A
correct?
single case study is,
Yes, sir. Thank you very much. And then you talked about the literature. Publications is the next question I was getting to. In order to publish, say, for instance, a clinical research study in the Journal of American Academy of Pediatrics, are you at all familiar with that process?
publishing an article?
Yes, sir. Well, specifically with the American Academy of Pediatrics, AAP, if I've got that acronym right.
All right, the way that works is
No, yes or no? Are you familiar with the process?
I think I'm familiar with the process.
Does that
I know what you're
include-
asking.
Does that include a review by the editorial board?
The editorial board has to approve the research, yes, and then
Thank you, Dr. Lesnick. They approve the research. Does that also include a peer review, opportunity for peer review? Yes or no, Dr. Lesnick?
so before it's published, it has to be peer reviewed.
Thank you, sir. Does that also include, if and when it's published, an opportunity for commentary to be submitted with regard to that particular public?
Yes,
So isn't it fair to say that the majority of what you've cited, when you cited the studies by Coates and Atkinson and Christian and Benenbaum, that those were case studies, not necessarily published in the AAP journal? Is that fair to say, the majority of them?
those were experimental literature,
Okay.
not published in the American Academy of Pediatrics, but published in Journal of Neurosurgery or biomechanical journals. There's multiple journals out there.
Thank you, Dr. Glasnick. And again, if they weren't published in the AAP journal, then there wouldn't be those safeguards or those guardrails like the editorial board review, like being peer reviewed, and also allowing for others to submit commentary on those articles.
That's absolutely wrong. You're
They would
absolutely
be-
wrong on that. You're
Okay.
absolutely wrong on that.
Okay, please go.
Okay, when I have published articles,
Yes, sir.
I rewrite our article, we submit it to the editor. The editor then looks across the world and identifies people who he thinks or they think might be appropriate to view the quality of this article to see if it's worthy for publication. They give their feedback to the editor. The editor then gives that feedback to the original authors, and a dialogue can develop. And where they say you should have said this, or you should point out that, or you should clarify this. And then the editor ultimately decides if it's worthy of publication, it is then published. Then what happens? And I've been an invited peer reviewer in that process. Then what happens is once it's published, it then becomes open to the general community to that. Whether you call that a letter to the editor or a commentary, the American Academy of Pediatrics uses the term P3R, post-publication peer review. That also is not an automatic just because it's done. And I have a number of those where I read an article, I either think it's wonderful or it has some flaws with it. I then write my commentary and to the editor. The editor will then send that commentary to the authors of the article in question, and then they have a chance to respond and so then a dialogue develops. And at the end of this process, if the editor decides that it is worthy of publication and furthers the dialogue in an area, then it gets published, and then that process can go on.
Makes sense. Thank you, Dr. Glasnick. And that's been your experience, but is it possible to have an article, a case study published without those safeguards? Is it possible for that to happen?
I don't know if I can answer that.
Okay, fair enough. But nevertheless, if an article is published in the AAP journal, we do know for sure, for certain, that those safeguards are at least in place, correct? Yes or no?
I can't answer for certain. I can say that is the standard process.
Thanks, sir. Fair enough. All right. So the majority of the case studies you cited, they were not published in the AAP journal. Is that fair to say?
Correct. They're published in other quality peer-reviewed journals like the Journal of Neurosurgery.
Dr. Glasnick, I'm just trying to get through the material, the questions that I have to ask. That's why I appreciate yes or no, but I think you've answered it. Thank you, Dr. Glasnick. You understand, you talked about biomechanical modeling. In fact, I think one of your articles you listed in your resume deals with biomechanical modeling. Really briefly for the court, that involves mathematical equations in physics, right? To try to mimic a living organism or the effects of, in this case, trauma on a living organism. Is that fair to say?
The journal we published, we had a live baby bouncing up and down in a jumperoo study with the accelerometer on its head. And yes, there were calculations in those kind of things, but part of that team was a trained biomechanical person. He wasn't a doctor, but he had that end of it. The pathologist was on that
Dr.
team as well.
Gladnick, so I'm gonna ask you, and Mr. Coleman's gonna get pretty frustrated pretty quickly. Please try to answer just the question that he's asking.
Thank you, Dr. Glasnick. And I get it. There are individual studies, there are exceptions to every rule, but generally speaking, the field of biomechanical modeling, it relies on mathematical equations, it relies on physics, correct?
Yes, and actually reconstruction and building models.
Thank you, and building models. And you would agree with me that when you're reconstructing, say, for instance, an accident scene or an industrial accident in a refinery, you've got certain data points. You've got the thickness of, you got skid marks and distances and speed ratios and calculations with regard to the refinery. You've got the thickness of the pipe. You've got the pressure that was going through the pipe. These are all things you would agree with me that are hard data that you can plug in for your mathematical computation.
Or for your reconstruction or your computer modeling.
Or for your reconstruction of computer model. But when you're trying to do something, when it relates to a living organism, there's something called biofidelity, right?
Mm-hmm.
And that means you can't mimic the thickness of a baby's skull, for instance. All right?
I can't concede that.
You can't mimic the tissue. There are limits, is it fair to say, with trying to apply biomechanical modeling to a living organism?
There are limits, but biomechanical research takes that into consideration. They know the quality of the bone, they research it, they are starting with human bone, they know the thickness, they know its flex, they study its flexibility, they study its tolerance for fracture. This is part of what they do. And it may not be perfect,
Sure.
but it is what they do.
So you would disagree. Find my information. I know exactly what it is. Brain injury, biomechanics, and abusive head trauma, a study by Rudy Castellani in 2018, Journal of Forensic Science and Medicine. Does that ring a bell?
No, I'm not familiar with that.
Let me ask you this. Would you disagree with the assertion that's made in that particular article that experts recognize the inherent challenges of the application of the concept of biomechanical engineering to trauma? And it goes on to say that many clinical biological factors are not adequately addressed or accounted for in experimental models. Would you disagree with that?
I can't disagree with that.
Sir?
I don't disagree with that.
I mean, because at the end of the day, when we're talking about biomechanical modeling, we're using either, most often, a crash test dummy, right?
It's used.
Yeah. And they're not necessarily biofidelic, if that's the right term to use, as it relates to an infant, correct?
That's true.
And they don't account for, while this is simulated in the laboratory context, it doesn't account for the real world context as it applies to living organisms, particularly infants, correct?
I think I don't disagree with that, but I'd like clarification on redirect.
Fair enough. I mean, for instance, you made mention of a clinical study. I think it's the Bouchon study, where we're talking about individuals who were measured for the RADS or the terminology radiance, but I think it's
Radian,
They
RADIAN.
locally refer to it as RADs, right?
No, that
No.
RADS is something else.
RADs, something else? Okay, thank you.
I'm not sure what it is, but it doesn't.
Okay.
It's a radians.
Okay, radiance. You were talking about the radiance, 10,000 radiance, can come from jumping rope or playing pee-wee football. But you understand that an infant, particularly a 2-month-old infant, like in this case, can't jump rope, right?
Correct.
You would agree with me that a 2-month-old infant can't play pee-wee football, correct?
Correct.
So that's kind of a little like comparing apples to oranges. Would you agree?
I think it can be a little like that, but again, we have data down to 7 months.
Again, data that's based on modeling. It's not necessarily biofidelity.
No, we have the Lloyd baby bouncing up and down in his jumper who completely squealing with joy.
That's a case study, not a clinical research trial or study.
No, that's not okay. That is a clinical experiment. The ball was bouncing with stuff strapped to his head. When you use the word case study,
Yes, sir.
case study, I interpreted that to mean it's like an individual report of someone falling down 3 feet and having a subdural. That's an individual case report. Now, when you talk about biomechanical study, where you start with a hypothesis, set up experimental criteria, and conduct that and report results, I don't think the term case study was not the way I was understanding that to be used.
I get that. Let's talk about those radiants. There was a note that I made about those radiants and the 10,000 number from jumping rope and playing pee-wee football. Are you familiar with the biomechanical engineering study done by Carol Jennings from 2017?
But yes,
Do you find that or believe that to be a credible study?
yes, actually, I don't dispute it. It was same part of the same.
Dr. Gillespie, yes or no?
I like
Find it to
that.
be credible.
I'll redirect. We'll go entirely through it and not bottom.
And I get it. I'm just trying to get through it, Dr. Gillespie. You understand that in her study, or in that study, the range was not necessarily, well, the peak range was from anywhere from 9,000 or 9,600 to 10,000 was the peak range for the acceleration, angular acceleration, before it became considered to be to cause injury. Do you understand that?
That is,
Or do I?
I think you have that wrong.
Okay.
What she reported was in her Africa study series, she built a 2.5 model, a 3.4 model, and a 17 model, which I went through. In this, the 2.5 kilogram is a 5.5 pound, and in the shaking of that, she reported 13,000 radians per second squared, and she also reported 26.4 G's of tangential linear deceleration. The interesting thing I found about that is that in the same setting, in the same laboratory, sitting there with the same picture taken, the shaking of her 3.4 kilogram model reported only 1,400 radians per second squared with a 10G linear deceleration. That is a statement of how fast those numbers fall off once the weight increases. So when you start talking about a 12, 14 pound. And so that my take on that article is, first of all, it's not new research, number one. That was all done back in 2002, published in 2002, and then only republished in 2017. But the first time I have an alleged shaken baby case involving a 5-pound newborn, I would be resorting to that. Any alleged shaken baby case of a 7.5, 8-pound infant, the appropriate data would be Carol Jennings' data from the same set of experiments in the same laboratory, reporting 1,430 radians per second squared.
And let's shift gears. Let's talk about the Atkinson study, just briefly. The Atkinson study, it dealt with children ranging from in ages from 7 to 16 years old. Is that your recollection?
7 to 16?
That's the information I was provided. You tell me if you have
No,
something different.
they were toddlers.
They were tops. I'm misinformed. I'm sorry. Thank you. Let's talk specifically about Dr. Stein's testimony. Counsel for the applicant just kind of glossed over it a little bit, but do you recall from reading the testimony or the transcript that Dr. Stein characterized Kaylin's brain swelling as massive brain swelling?
Yes, I agree.
Okay, and you understand that there is a big difference between brain swelling and massive brain swelling, correct?
Well, it's a big difference. I mean, as I showed you, that's right.
Difference.
There, I guess some difference. Go ahead.
But you wouldn't characterize massive brain swelling as being significantly different from, let's just say, minimal brain swelling?
I would classify any imaging documented brain swelling as a significance.
Okay. What I'm getting at is, while there's a difference between massive brain swelling and brain swelling, there's also a difference between retinal hemorrhaging that's multi-layered and what's referred to as TNT, too numerous to count, correct?
I think that needs some clarification on redirect. Very little difference between multi-layered and too numerous to count. Hard to have too numerous to count and not have multi-layered. And so that's.
So you would disagree with any expert witness, pediatrician, clinical professional that says massive brain swelling in conjunction with too numerous to count, retinal hemorrhaging that extends out, that's multi-layered, that extends out to the periphery, is indicative of abusive head trauma in an infant. Would you disagree with that?
I would want to revisit that on redirect. It is, you said, indicative of
Yes.
abusive head trauma without giving me a mechanism. Okay. I think if you slammed a kid's head down, broke it, cause, you could have massive brain swelling. Cause increased pressure, which has been recognized to be able to produce extensive retinal hemorrhages to all four quadrants. So, but you could that same event could be an accident. So that to say indicative of, it is possibly consistent. It is consistent with, but it's also consistent with other explanations.
Thank you, Dr. Velaznik. Let's move on to Dr. Moore's testimony. Her testimony before she had her recent epiphany. She testified that she ruled out any tumor. Do you remember that from her testimony? She testified that the pupils were unequal, that the right eye was slightly smaller than the left eye. Do you recall that?
I recall that, but I would think that at the autopsy time.
Is that a yes?
Dr. Moore?
Is that a yes? Do you recall that testimony?
I recall there was testimony that pupils were unequal, whether it came through her or whether it came through someone else or whether she recanted what she saw in the chart.
Yes, sir.
I can't answer that now, but as the pathologist, 8 months later.
You answered my question, Dr. Velaznik. You can't recall that. Let me ask you if you recall whether or not she said that the effect of these injuries would have been immediate. Do you recall her saying that?
That would sound consistent with what she would have said.
Yes, sir. Thank you very much. Now let's shift gears. The Rourke case was the subject of quite a bit of questioning by counsel for the applicant, and I just want to briefly address the Rourke case. You understand that the Court of Criminal Appeals, and I'm looking at the notes and from that case, says that Rourke case was different in that it was a circumstantial case, which was part of their circumstantial evidence, which is part of their calculation. for-
Your Honor, I'm gonna object to that question because he says the Court of Criminal Appeals said it was different, but he didn't say different from what. So I think it's a confusing question that Dr. Glasnick cannot answer.
I'll rephrase the question.
Sure.
You understand that the court pointed out that this was a circumstantial evidence case, correct?
I don't recall the details of the case that clearly.
Thank you, Dr. Belasnik. You understand that the Court of Criminal Appeals in that opinion also says there remains, and I'm quoting from the opinion, there remains some controversy.
I don't dispute it, said there remains some controversy. I can't dispute that. I don't know the exact wording that they used.
And that this, quote, new scientific knowledge should be considered as a whole, quote, in this case.
I don't dispute that. I don't have the, in front of me, I don't have the words, but I don't dispute that they might have said that.
Far cry from a hard and fast rule across the board, wouldn't you say?
My memory of the war case is,
Yes or no? Far cry from a hard and fast rule across the board.
if what you're saying is there, the summary paragraph that I'm familiar with of the war case said that short distance falls can be damaging, chronic subdurals can rebleed,
That's not-
retinal hemorrhaging.
Dr.
know,
Glasnick,
Dr.
you're not answering the
I
question.
know, I know you want to say.
You're trying to get it in,
Oh, yeah.
but just answer his question.
Okay, but I don't have the 60 pages in front of me.
If you don't,
If you don't know, just say you don't know.
Okay, great.
Thank
Yeah.
you, doctor.
Thank you. That's a helpful answer.
Yes, sir. So you referred to shaken baby syndrome, and these are your words, as quote, a hypothesis. Do I recall your testimony?
I believe that's how I refer to it.
Yes.
It's only a hypothesis.
And you, by calling it a hypothesis, you understand, and I'm reading from the Journal of Pediatrics. In fact, the published article from 2016 by Dr. Sandeep Narang, which states, and Dr. Lindbergh, by the way, who's one of the state's witnesses here, that states that the concept of shaken baby syndrome or abusive head trauma in infants has been surveyed by 1,300 physicians, and that 682 of them responded, and that the majority of those physicians who are frequently involved in evaluating injured children, you understand that the majority of them support and consider the science behind shaken baby syndrome to be generally acceptable. You understand?
Yes, that's what that report says, which I find very significant. We can revisit on redirect.
Yes, sir. All right, but that's what that report says. Thank you for answering my question, Dr. Glasnick. So by calling it a hypothesis, you would disagree with those 682 clinicians who responded to that survey conducted by Dr. Narang.
That, yes,
Okay, thank you, Dr. Glasnick. Now, you mentioned, you were kind enough to mention the 2001 AAP, American Academy of Pediatrics policy paper. You also were kind enough during your direct examination to mention the 2009 AAP policy paper. But what I did not hear is you talk about the 2005 policy paper by the AAP. And as I recall, and here's my question, I'm getting to my question, I promise. We're looking for that here. Of course, I can't put my finger on it right now. I may come back to that, doctor. I just can't put my finger on it. Oh, here we go. Yeah, that's right. Staring me in the face. You understand in that 2025 policy paper that they reaffirm their recognition of the abusive head trauma and recognize that it can be inflicted head injury in children. You understand that?
I'm familiar with the 2025. I'm familiar with what you're saying. They reaffirmed. I'm not sure I'm totally agreeing with all that, but yes, I'm familiar with the 2025 It's 630 references and it's about 70, 80 pages long.
Yes,
Is it 2025 or 2005?
2025. It's a reaffirmation. In fact, for the record, I'll read into the record. It's abusive head trauma, is the title of it, abusive head trauma in infants and children, policy statement of the American Academy of Pediatrics, volume 145, number 4. And it's a April 2025, what they call a reaffirmation. And Dr. Glasnick, you understand in that reaffirmation, they set forth, or they say that the cornerstone of abusive head trauma evaluation remains what they call a skin exam, a skeletal survey or x-ray, a head imaging, a ophthalmology consult, and a caregiver history. You understand that, right?
That sounds appropriate.
Okay. And you understand that they do not use the term, what you've referred to as the triad. In other words, limiting it to the abusive head trauma, limiting it to subdural hematoma, retinal hemorrhaging, and or the altered mental state. It's not just limited to those things, what you refer to as a triad. Understand that?
Oh, correct.
You understand in that same article, they go on to say certain patterns of retinal hemorrhages, specifically those that are too numerous to count in one or both eyes that are present in layers and extending out to the periphery, are more common in abusive head trauma than in accidental head injury. Would you disagree or dispute the fact that they said that in that study?
I would not disagree that they said that, but I would disagree with the basis on which they are basing that statement.
I understand. Would you disagree with me that that same study, that reaffirmation in 2025, goes on to talk about shortfalls that are often defined as less than 5 feet? Although a few isolated case reports have been identified, the potential mortality of some shortfall events have been clarified, and the extreme rarity of those shortfalls it's extreme rarity as a cause of severe neurologic injury or death in young infants. Would you disagree with that? If I represented to you that that's what that study says?
I don't disagree with that. We can visit on redirect.
Yes. And lastly, two more points from that study. They go on to say subsequent studies have highlighted the biofidelic limitations of the earlier work and have validated shaking alone as a mechanism for inducing infant brain injury. Would you dispute that if I represented to you that that's what it says?
I would not dispute that.
Okay.
I would revisit this on redirect.
Yes, sir. And I think we've finally gotten into a rhythm here, Dr.
Not yet.
And my last point on that article from 2025 is that the policy set forth by the AAP is that the sound evidence, according to them, sound evidence-based literature supports the conclusion that both inflicted rotational and contact forces to the head can cause brain injury, intracranial hemorrhage, spinal hemorrhage, and or injury and retinal hemorrhaging. Would you disagree that that is represented in that article?
I don't disagree with that. That's in that article. I would want to clarify and fine tune on that. As I say, I'm not disagreeing that shaking can cause injury.
Understood,
Okay,
Dr. Glasgow.
that will redirect.
Thank you, sir. And again, this is published in the American Academy of Pediatrics Journal, which has those guardrails we talked about, the editorial review, peer review, and also the commentary opportunity. On page 12 of your affidavit that was provided to me by defense counsel, paragraph 30 of page 12, you yourself state that current biomedical research indicates an attempt to shake Caleb. How do you know that? How do you know for certain enough to quote that in your affidavit that there was an attempt to shake Caleb?
Must be a typo. I don't recognize the attempt. Alleged is a word I frequently use.
Do you need me to get you your affidavit to take a look?
Yeah, let me see that.
Please.
The whole sentence not making it. I lost.
I'm sorry, sir.
I don't recognize the sentence that you're,
I understand.
and I don't apologize, I do have typos.
No, I understand. So I'm looking at page. Well. And see if I got it wrong, paragraph 30. May I approach the witness, sir?
Yes, sir.
You take a look at that. Wait, please. I just got out of order. Let me do this.
Okay.
At least my notes say that somewhere in that paragraph, you say current biomechanical research indicates an attempt to shake.
Yeah, an attempt to take Caleb, who at the time of presentation weighed about 11 to 12 pounds, would produce between 500 and 1400 radians per second squared. So he fell halfway in between. So if he were shaken.
But wait a minute, that's a yes or no. You say that there in your paragraph, right?
Yeah,
Okay.
and we can come back to that.
Yes, please. But an attempt, you're basing that, you're getting that on representations about the door frame.
Your Honor, I'm gonna have to object to this testimony because that is not what that affidavit says. I mean, if he wants to read it, then we'll know what he's talking about.
Do I have that?
I can hand you my copy if you want to look at it.
I feel like I've got it.
You do have it
I-
somewhere.
Where?
Your Honor, it was filed with the initial rates. It was a while ago.
I guess I want to make sure. Can I just see the paragraph?
You can. What I'm focusing on, Yar, is the word attempt. That's all I'm getting at.
I think if you take it in context, it's not the legal attempted to do something but didn't do it all the way. It's indicates that an attempt to shake Kaylin, who at the time was this would produce between. It's doing the math on the how.
The radiance. I guess what I'm getting at, Judge, is the word attempt. I'm not using it in the legal sense. My question is, he's speculating by calling it an attempt, where we got actually an admission by this defendant.
And Your Honor, that, as the court said, that's not what it says.
I don't think that's how I read it.
Okay,
That it was an attempt to do it. I think it's how he's phrasing, getting the mathematical equation for the radians
Yes, ma'am.
per second squared.
Yes, ma'am.
Thank you.
If I can ask you this way, Dr. Glasnick, the defendant told law enforcement he shook Kaylin. He didn't tell law enforcement that he attempted to shake Kaylin. Is that your recollection from reading?
That came through, but the shaking was not that defined. And my statement there,
No, you kind of, yes or no? I mean, he told law enforcement, I shook Kaylin, albeit he had a reason or excuse for it, but he said, I shook Kaylin. Yes or no?
that I think is in the,
Sir,
it is in the statement.
so that's a yes. He didn't say he attempted to shake Kaylin. Yes or no?
Right.
That was right.
Yes.
Yes, Dr. Glasnick. You've never testified for this prosecution. You mentioned that, right?
Right.
In the 25 years that you've been testifying in family court and as an expert witness, you've never testified for the prosecution.
No, I'll review a case for you if you like, and we'll see how it goes.
I'll take it under advisement, Dr. Lyle. Let me see. I just got a few more questions. So let me make sure I get my outline. Dr. Glasnick, you didn't cherry pick those case studies, did you? In other words, you didn't just selectively pick out those case studies that you testified to here today, right?
But the following, I follow the evolution.
Have you provided this court through your testimony all of the different perspectives through that are out there across the board for those case studies?
I don't know how to answer that. There's hundreds of cases out there. I follow the logic of the ones that I find most relevant and most credible.
Thank you, sir. That you've answered my question. The ones that you find most credible. You are not here today to substitute your judgment for the judgment of a clinical pediatrician that see children and treat abusive head trauma on a day-to-day basis, are you?
I don't understand that.
Now I'll ask it again. You're not here to substitute your judgment for a clinician, a clinical pediatrician who on a day-to-day basis sees, evaluates, diagnoses, and treats abusive head trauma in children. You're not here to substitute your judgment for them, are you?
I'm here to bring the science, available science to the courtroom relative to this case. That's what I'm supposed to do.
Appreciate it.
Let me start, Dr. Glasnick, with the prosecutor's question about you don't really know what happened because you weren't there, right?
Right.
Okay. Now, you know Dr. Edwards. Do you think he was there?
No,
Do you think Dr. Yu was there?
no,
And do you think Dr. Stein was there?
no.
Okay. So Dr. Stein said he knew what happened, right?
That's what he said.
But he wasn't there, right?
No.
Okay. So do you think since he wasn't there, he can still know what happened?
No.
Now, there was also a lot of the questions the prosecutor asked you. He focuses on abusive head trauma. But what we're talking about here is shaking alone, right?
Right.
So a question about abusive head trauma isn't necessarily really even addressing what we're talking about. Isn't that right?
That's absolutely correct, because abusive head trauma in the 2025 is defined as injuries from either impact or shaking. So the term can include both, and if you muddy it together, you get answers that make no sense.
So that really leads me to my next question. You've testified multiple times around the country on these kinds of cases, right?
Right.
And it seems to be, tell me if I'm wrong, it seems to be a typical approach by prosecutors is to don't say shaking, just say abusive head trauma.
Correct.
Why do you think they do that?
Because they can't defend shaking. That's it. And in 2009, it says, don't use this term because it is distracting us from convicting these perpetrators. How is it distracting? Because defense attorneys are filing Daubert challenges to make the accusers come to court and defend with quality experimental science to validate what they're saying, so that they can, if they're not forced to define how they're saying the child was injured, they are escaping being put under that lens. So that every case I get to, I tell the attorneys, your first role is to force the accusers to declare exactly how and when they are saying this child was injured and how their alleged mechanism of injury accounts for brain injury, accounts for subdural bleeding, and accounts for retinal hemorrhaging. Make their feet in concrete so we can then bring the literature to court to challenge that. And so leaving it vague, term abusive head trauma has a nice big adjective abusive in front and has head trauma, but it is totally non-specific for mechanism. It is vague as to mechanism, which is what my understanding of the Rourke decision was.
So the Rourke case is it your understanding that was about shaking alone? I mean, it wasn't about abusive head trauma generally. It was about this new science concerning shaking.
And shortfalls and retinal hemorrhaging.
Right, but concerning whether or not shaken baby syndrome, that theory accounts for these injuries, right? Now, when the state's doctors testify, which is going to be after we're through with you testifying, is it going to surprise you if every time I say, I want to ask you a question about shaking, that they answer it with an answer about abusive head trauma? Is that going to surprise you if that's what we hear?
Not in the least. And my follow-up question would be, please define what mechanism under that category we are talking about, because we're talking about shaking in this situation, not blunt force or some other mechanism of injury.
Okay. So what would it surprise you that a month or so ago, I took Dr. Edwards' deposition, who's one of the state's witnesses, and I asked him questions about shaking. And he got upset with me and said, you keep talking about shaking, because he didn't want to talk about shaking. Does that surprise you to hear that?
No, not at all, because shaking is the mechanism under scrutiny. Blunt force is well recognized to cause injury, and shaking is the mechanism of concern.
Okay, so let me switch gears a little bit. We mentioned earlier that you were a witness in the Rourke case, right?
Correct.
And in fact, the Court of Criminal Appeals said specifically that they found Dr. John Galasnik's testimony in the Rourke case to be credible. Right. And they relied on your testimony along with a substantial amount of other evidence, but they relied upon your testimony in finding that there's new science in this area.
Correct.
Okay. And of course, you understand we're here talking about science, right?
Correct.
We're here talking about, is there new science?
Correct.
And the Court of Criminal Appeals in the Rourke case, did they say that every single doctor in the world agrees that they're with the new science?
No.
They recognize that there are some people that are going to disagree, right?
Correct.
But do you recall in the Rourke case that the Court of Criminal Appeals, the way they described the doctors who refused to accept the new science, they called them engaging in the ostrich effect, meaning like sticking their heads in their safe.
Perfect.
That was, I didn't suggest that phrase in anything I followed. That's what the Court of Criminal Appeals said. Right. Okay. Now, what is a job of a medical doctor in this area? Is it your job or Dr. Edwards' job or any medical doctor to say whether or not this defendant is guilty of a crime?
Not their job at all.
Okay, what is your job in this area?
My job, or Dr. Edwards' job, is to look at the available history, the available objective data, imaging, laboratory, X-rays, to then formulate a differential and eliminate what can be eliminated and match it against the currently available relevant literature to see if, number one, it can be explained by a non-abusive phenomenon, matching the history, or if it is only explained by an abusive injury by a mechanism that is substantiated with science.
Okay, so your job is to bring us the science.
Correct.
And it's the police job to investigate.
Correct.
The court's job to adjudicate court cases. But you're not here to do those things.
Correct.
Is Dr. Edwards here to do those things?
No.
Is Dr. Stein, was his job in 2004 to tell us this man is guilty of this?
His job in 2004 as an intensive care provider in the ICU would be to care for Caleb. And it's not, would not have to at all go out on a limb and say how the child was injured or whether the caregiver did it or didn't. That was going, his job at the hospital.
I mean, it seems like at least in this area, there are doctors working in the child abuse pediatrics world. They seem to get out of their lane. I mean, they're doing things that doctors shouldn't be doing. Is that right?
Yes, I guess a way of, I would frame it is that in the hospital, you have treating doctors and you have consultants. You have people who are treating the patient. They're ordering the IVs. They're ordering the fluids. They're ordering the nutrition. They're operating to let the stuff out. And you've got consultants. The child abuse doctor is not treating that patient at all. He is there to assess the data to try to come to some kind of conclusion whether he thinks this is abusive or not abusive. So he is the child abuse doctor generally is not writing any orders. He make recommendations. Please do the MRI, but someone else has to order it for him. So that now Dr. Stein in 2000 was functioning as the child abuse doctor. I don't know that, but in this day and age, these big hospitals have their child abuse specialist who is not treating the patients. They're simply there to.
So they're consultants. They're consultants. So
just like radiologists.
So let me switch gears again a little bit. The prosecutor was asking you questions about the Atkinson study, Coates study, Benenbaum study. I wasn't real clear what the point was, but it sounds like he was asking you questions in a critical manner of the Atkinson, Coates, and Benenbaum studies. Is that how you took that?
That's how I took it.
Okay, who are these people?
Well, the Atkinson study, I think, is very significant because the Heffler Society is the professional society of the child abuse physicians across this country. And what the Heffler Society Atkinsons did was, or Starling was, I think, behind most of it, was they sent a questionnaire out to all the child abuse physicians in the country, asking the question, have you had cases of witnessed short distance falls with occipital impact, which had subdural bleeding, where you accepted the count of the fall as valid? And they got about 23, 24 responses back of yes, of cases. And then they said, well, do you have the imaging and we can assess? And that's how they narrowed it down. But that article was published by the child abuse doctors themselves, gathered from the board certified child abuse pediatricians in this country who were members of the Heffler Society. That is not an article put together by denialists or
Well, so just to be clear, it wasn't, you didn't put that article together.
No.
Okay. Dr. Atkinson is a child abuse pediatrician, board certified child abuse pediatrician, right? Dr. Starling is one of the well-known board certified child abuse pediatricians.
Correct.
Right. They're the ones that put that article together.
Yes.
Okay. So the state seems to take some issue with that article, but it was those are the people that put it together, right?
That's right.
Okay. Coates and Birnbaum, are they they're not you, right?
Right.
Okay. All right. Well, let me move on from that. Now, the state asked you a whole series of questions about biomechanical engineering. And it sounds like the state's position is there something wrong with biomechanical engineering? Is that how you took those questions?
Kind of, and they didn't start with with what a lot of it springs from in these kind of cases. For example, in terms of the skull fracturing from impact, they start with human skulls, infant skulls. They measure the thickness. They measure the flexibility. They measure the force to break it. And then when they build their model, they incorporate that data into their model as best they can. They realize there's limitations to that, but we are not just out of the clear blue grabbing this kind of stuff. In terms of rib fractures, they got ribs from newborns, 1 month old, 2 months old, 6 month old, 5 years old, 20 years old, and they take these ribs and they go into the biomechanical laboratory and they subject them to 3-point bending until they break. And they report that the infant rib breaks at about 2 pounds of force in 3-point bending. That is not out of the blue. They start with human tissue. The same is true of the neck injury. They got vertebral columns of cadavers. You could say, well, the cadaver's not quite in the living, but they start with human tissue. And they just like any biomechanic, any engineer, they take this thing and they stretch it and they bend it and they say how stiff it is and they pull it till it breaks. And they come up with a number so that they're not starting in a void. Now that some numbers they cannot get at, but they make every effort to start with data based on human efforts. Same is true like range of motion. You start with a range of motion in the neck. You know what it is before you build your model, so that the stiffness of the neck, the flexibility of the neck, range of motion of the neck, this is all built into their modeling efforts.
So to your knowledge, is biomechanical engineering a legitimate scientific area?
Oh, absolutely. It's got PhD programs, books written, and departments at major universities across this country.
And you're aware that some of the very same arguments that the prosecutor's making in his cross-examination of you trying to attack biomechanical engineering, those very specific arguments have within the last year and a half been rejected by the Michigan Supreme Court and the New Jersey Supreme Court.
I object to the Michigan and the New Jersey references because they have no precedential value in the state of Texas.
Correct. Other states have looked at it and found that actually
I'm gonna stop you there. We've already talked about that.
I'm done with that. There were some questions about the Jenny study that you had some things you wanted to comment on.
yes, I found it remarkable that this Jenny study that was published in 2017 was actually not done in 2017. It was originally done in 2002 and published in 2002, and simply the data was simply republished in 2017. I don't know the ethics of that necessarily, but when you look at it, everything that was reported in 2017 is in the 2002 rendition. And if you look at the extracted images of the shaking, the shaker's arm, hand, clothing is exactly the same. I presume that I have to that she published it in 2002 and felt it didn't get the notoriety it deserved, and I guess republished it. But my point there is that at the time that study was done, it was part of the Aprica study. The model was the 2.5 kilogram Aprica model. She, in the same laboratory, cranked out her 3.4 kilogram Aprica model and got a crabby 17-pound model, all in the same room, all with the same equipment, and shook them. And she reported in the shaking of the 5-pound model the 13,000 and the 26.4 Gs. But by the time she was reporting the 8-pound model, those numbers had fallen dramatically down to 1,430 radians per second squared. That's a huge drop. And 10 Gs. So that my position on that study is that, first of all, this was been out there for 25 years before it was republished, and that the first time I have a shaken baby allegation on a 5-pound baby, I will give her data some credibility. But anything 8 pounds or above, I'm looking at the same researcher, the same team, the same model construction, was reported only 1,430. And the other thing I find most remarkable, shockingly remarkable, about that study is that the head in shaking of a baby cannot hit the back. If the head comes forward, chin can hit the chest, but the head cannot hit the back.
So what's that have to do with the Jenny study?
Everything, because she reported a tangential deceleration, 26.4 Gs. 26.4 Gs, force is mass times acceleration. You take a 1.5 pound head by 26.4 Gs, and you get about a force of 40 pounds of force yanking to stop this head. And all of this force has to be stopped by the ligaments of the anterior neck. The ligaments of the anterior neck. And hit that. And it's even more than 40 pounds of force because that's the center of gravity of the head. And the neck is about 8 centimeters away from that. And the vertebral column is about 1 centimeter. No, it's like a claw hammer that's hooked on a nail on the board. And if I got a nail on the board, I got it hooked like this, and I pull with 40 pounds of force up here, the force pulling that board out of the neck is about 160 to 200 pounds of force. And the demonstrated force to get ligament failure, starting with real human tissue, is about 40 pounds of force. And in one study from 1874, believe it or not.
Well, let me stop you for a second.
Yeah.
Can you what is I think you're describing a flaw in the Jenny study.
I'm not defining a flaw in the study. I'm defining her results. And if I apply those results to the real world, what I'm getting is a neck that is destroyed in an abusive shaking of an infant that small.
So her study does not come to legitimate conclusions. Is that what you're saying?
Right. I think that if her study would, my conclusion was, yes, she may report this in terms of head rotational acceleration, but to get that, you're going to have basically almost a decapitated infant in your hand.
Okay. Let me move on. The prosecutor.
So hold on.
I'm sorry.
So as much as we've talked about that study, we're saying that we don't like it. In short terms, I felt like when you first testified earlier during direct, that all of that was important because you could look back and say, if it was 5 pounds, it was this, if it was 8 pounds, and then if it went up to 17, it was different. But now I think I'm misunderstanding that you don't believe that those are either correct or transferable into the real world with a real baby.
I am saying that I don't dispute the results, because I agree with the results, but if you apply it to the real world, that the injury of a shaking of a 5-pound baby would not be subdural retinal hemorrhaging brain injury. It would be basically a broken neck
And
coming
her
off the
study
body.
said nothing about any neck injuries.
There was no neck injury in this case.
Carry on.
Okay. The prosecutor talking about Dr. Moore and her recantation affidavit and saying her testimony was wrong under current science, he described it as an epiphany. Okay. Does her affidavit say she had an epiphany, or does it say she studied the new science?
She studied new science. She didn't have an epiphany. Okay.
And like we talked about earlier, there have been a number of doctors like Dr. Moore that have studied the new science and accepted it.
Correct.
And changed their previous position.
Yes.
Okay. It's not is it fair to call it an epiphany?
No, it's just following the evolution. Medical science is always evolving. And to believe what was believed 10 years ago and as versus what we understand now is just human growth.
Okay. Let's talk about the Narang report. I think it was the 2025 AAP position paper that not Dr. Narang was the primary author of. Is that right?
Correct.
And I think he was also the primary author of the 2020 paper.
Right.
And Dr. Narang is both a physician and a lawyer.
Correct.
Right. Okay. So you had some comments you wanted to make about that 2025 position paper.
Yes, and what I find it a little stunning, is that if you go to page 28, bottom paragraph of on the left column, it basically says that we, in terms of history of these kind of cases, that something like in 600 cases of adjudicated abusive head trauma, that the history that was offered was of something like a short fall. Okay, so the example of 600 or so cases adjudicated, where they looked at the history that came through, there's more than that in the literature, there was a history of a short fall out there, but the person was convicted. But then you look at the dates of those articles that were relying on that for that fact, and they all were predating Atkinson's 2018, predating at a point in time when a short distance fall could not be acceptable to account for the triad constellation. But once you have Atkinson out there and a short distance fall that drops as low as 28 to 30 inches and do it. What I find stunning about the Narang 2025 is that paragraph at the bottom of page 28 on the left column, to me, is basically an admission in print of a potential 40% error rate in all prior abusive head trauma convictions.
Explain that again. Why is that an admission of this error rate?
Because because in that article, we looked at 600 cases from before Atkinson 20. They convicted them all. Their history was a short fall, and they were convicted because prior to December of 2018, a short distance fall could not account for the triad. Whether the patient lived or died, it could not account for the triad for the official position of the American Academy of Pediatrics. So these people were, I don't want any details, but on the surface, they were convicted. They had a short fall history. I dropped my baby. Oh, that can't do this. You must have shaken it. They were convicted and sent to jail. And if that happened, but now once we know after Atkinson that a short fall can absolutely do it, and what that says is all those testimonies were in error, which basically leaves one at a potential 40% error rate in prior conviction. And the implications of that go much further because as I mentioned previously, when you talk about clinical case series, where they say, we looked at 100 cases that we decided were abusive head trauma, that we can and therefore we analyzed them and saw that 85% had extensive retinal hemorrhages. What that says is that if there is a potential 40% or greater error rate in the data going in over here, that basically every clinical-based statistical analysis article based on a case series prior to December of 2018 is now in statistics what you call garbage in and garbage out. It cannot be relied on.
So let me make sure I understand this. So it is correct that the most common thing that caregivers report to the police or the medical personnel on these cases is that the child had a short distance fall. That's the most common thing.
It's about 40%, and 40% of 40% of the cases, yes.
And maybe they're not doing it anymore, but certainly back in the 2000s and 2004 and during that time period, that those reports of a short distance fall were routinely disbelieved, and the authorities just said that caregiver is lying.
Yes, had to
Right.
check the baby. Had to
Okay.
check the baby.
And what the importance of the Atkinson study is their own people confirming short distance falls as a cause of these conditions, right?
That the short distance fall can cause the triad, may or may not be fatal, and that is a remember the prior position is that the constellation of these findings does not occur in a short fall.
Well, and the point is that when somebody says, well, something happened to these children, for the most part, the something is a short distance fall,
Right.
which we now know because of the Atkinson study.
Right.
And so do child abuse physicians, pediatricians like Dr. Narang, I don't know, do they accept the Atkinson study now?
They have to, they did it.
Okay, it was their study, right?
Yes.
Okay. All right. So is there anything else about Dr. Narang from the questions that the prosecutor asked you that you think is important about his articles that you need to tell us about?
Yes, the Narang 2016 article was what Dr. Narang and team did. They sent out questionnaires to not necessarily the child abuse physicians, but the doctors in ER doctors, neurosurgeons, pathologists across the country to get feedback on their understanding and acceptance of the diagnosis of shaken baby syndrome and abusive head trauma. And they got these numbers back. But remember, 2016, when this was done, that short distance falls could not account for these findings. Retinal hemorrhaging required shaking. That's what they were taught, and they're not running around trying to. This is what, in their practice, this is what they were taught and practicing and implementing in their practice, at least through 2016. Well, my point of view is, though, that the final effort, failing to validate shaking as a primary cause of retinal hemorrhaging, failing to validate shaking as a primary cause of subdural bleeding and brain injury, did not get published until after that.
You mean the Atkinson?
Until after this survey done by Dr. Narang in 2016.
So in 2016, Dr. Narang did this survey.
Right.
He got whatever results he got, but that certainly didn't account for the Atkinson study because that came after.
Right, and what that tells me is that study by Narang, I'm not disputing the results. What it gives is the penetration, the acceptance of the prior thinking throughout universally through the medical community based on the 2001 AP that no longer dilates exclusion, short distance falls can't do it, retinal hemorrhaging has to be shaking. And then we get to 2018 when you have the Atkinson's article, you have the failure to produce retinal hemorrhaging with shaking, you have the early revision of the American Academy of Pediatrics downgrading the potential for retinal hemorrhages to allow you to tell abuse from non-abuse, so that my take on all that is that it is almost frightening. Is that I think it seems to me that given now that the researchers and the child abuse community, Cindy Christian was doing the Piglet study, Atkins and Starling were doing the short fall study, do they have some ethical obligation to go back and launch a major re-education phenomenon of every investigator, every police department, every court, and every ER doctor in this country?
Objection to the narrative form.
Let me ask
Yeah.
that question. So is it curious that in 2016, Dr. Narang did this survey. And here we are 10 years later. And in this 10-year time period, you've had scientific study after scientific study that shows you can't cause these injuries by shaking. You've had court case after court case from coast to coast in the United States, where courts have found you can't cause these injuries by shaking. You've had the Swedish government appoint a committee to study this. Yet here we are 10 years later, and they have not done an update. They haven't sent out another questionnaire to see what people think now.
Or launched a re-education campaign.
Okay, I understand the re-education campaign, but maybe they should ask what their doctors think now, because a lot's happened in 10 years, right?
Correct.
Okay. And let me just ask you one question, because the prosecutor brought up the alleged confession to shaking by Mr. Garner. There was nothing in that confession to violent shaking of this baby, was there?
Not what I saw. It was to revive, to wake him up, to get a response that we call a resuscitative shake. That's why at the beginning of this testimony I said, when is this a shake? Is this a shake? Is this a shake? An abusive shake is.
Well, let me put it this way. The child abuse physicians agree, and their position is that their whole theory is based upon a violent shake, right? So if somebody says they shook their baby, but they don't say I violently shook my baby, are they confessing to what the child abuse physicians are even talking about?
In my opinion, no, because back when I was in medical school, you found somebody down, the CPR teaching was shake and shout, shake and shout.
But the question is that even a confession?
No, in my opinion.
That's all I have. Thank you, Doc.
And I have about 3, maybe 4 short questions. Dr. Glasnick, either you say shaken baby syndrome, or you say abusive head trauma. You forgive my language, you're kind of damned if you do, you're damned if you don't. Didn't AAP previously say don't call it shaken baby syndrome anymore?
Correct.
So if we being the state, and our experts are referring to it as abusive head trauma, we're essentially complying with the AAP guidance. It's not some effort to obfuscate or confuse the court. We're simply complying with the AAP guidance, correct?
I can only partially agree with that, in that you then have to say injury by abusive shaking or injury by impact, because that's what the definition of abusive head trauma is. I didn't say that very well.
Well, that's quite all right. I think you've answered my question, although I didn't follow it. I think you answered it. Let me just move on. There was one question I neglected to ask you. It was about your study, one of your publications, having to do with infant choking dysphagia, I think is what you call it, dysphagia
Right.
choking. Was that based on a study, or in part based on a study of a Xavion Thomas?
Correct.
Okay. Also, let's see, we got something else there. Your conclusion that the plausible alternative very well may have been epidural hematoma that resulted in intracranial venous thrombosis. Would it surprise you to note that in the 2015 study, Chandray study, CHOUDHARY, that study indicated that nearly 70% of children diagnosed with abusive head trauma had some form of intracranial or thrombosis of the intracranial venous. Would that surprise you?
No, that's what they said. There's a lot of interesting background on that, but prior to that, what they're saying is that
Yes or no again?
okay,
Doc.
that's in the article. Yes.
So it's not so abnormal, at least based on the Chandray study, correct?
Correct. It is a finding which, in the presence of many cases that were adjudicated as if you had trauma. In hindsight, they looked back and saw it was there. But impact can set it off, medical conditions can set it off. And so so it becomes a very, very clear mimic.
Yes, sir. And last question, did you bring with you today your certified expert witness affirmation recommended by the AAP?
No, I did not.
Did you execute a certified expert witness affirmation?
No, because I find it inadequate.
I understand that you find it inadequate, but you understand that's what the AAP recommends for any expert witness testifying about these types of matters. Please, I'll let you answer.
I want to read the record, deal with that.
But yes or no?
Yes.
You recommend that?
Yes.
Before you take the stand, you certify a expert witness affirmation, and that's so that this court and everybody knows that you have no conflict of interest or any other personal interest in the subject matter that you're testifying about, correct?
And it's not how I take it.
Well, I understand it's not how you take it, but could that be an interpretation by some?
It might be an interpretation.
Thank you.
Just a couple. Dr. Edwards, do you have a conflict of interest on this case?
No.
And what is that certification? What are they talking about?
Has policy statement on expert witness testimony. And it actually was originated out of civil liability, where you've got a malpractice suit and they're trying to make sure someone is not giving, for $1 million settlements, false testimony. So they want you to disclose to the attorney hiring you that what your actual background and certification is. My problem with their form that they generated, it insisted that one have relevant clinical experience in order to come in and testify. If they should change that to have relevant experimental background or special knowledge, I would be happy to sign one. But it's here to be an attempt to elevate subjective clinical diagnosis over solid science. And again, my position is when an attorney approaches me like you, I warn them right up front. I go through in great detail what my weaknesses are, what my strengths are, what I can testify to and what I cannot testify to. And then I go much more than simply giving you a statement that I think I'm qualified. And I think we've been through that.
Well, but for instance, you say we needed to find a radiologist on some of this stuff.
I'm not a radiologist. They will challenge. They will say, Dr. Klodzik, you're not a radiologist.
I mean, there are things you're qualified on and some things you're not, right?
Right. And I need to warn you up front that the prosecutor is going to ask me these questions. And if you don't, I can tell you how I will answer. And if you're not satisfied with that, let's get somebody else under the microscope that is far more detailed.
And nevertheless, there's one group we know that thinks you're a credible, qualified witness, and that's the 9 judges of the Court of Criminal Appeals.
Right.
Maybe not all 9 of them, I overstated, but the majority of the judges on the Court of Criminal Appeals believe you to be qualified to give the testimony that you give.
Yes.
And to be credible.
Right.
One last question. What's this Chowdhury? What's the Chowdhury stuff?
The background on this is that this intracranial venous thrombosis was not really high on anybody's radar. It was not talked about that much. It was kind of chugging along. And along about 2011, 12, there was a case in Pennsylvania where the Diaz and Chowdhury had labeled it abuse, and that it was reviewed by a different group of specialists who pointed out that there was intracranial thrombosis that accounted for everything. And the court decided that they agreed with it, that it did not account for that. And then subsequently, Mark Diaz and Chowdhury were sued in a civil suit. And then they cranked out this article to try to defend their position. So they went back through and looked at all of the old cases and were seeing venous thrombosis, cortical vein thrombosis in multiple cases. So then they tried to assert that, oh, yes, it's here. We were not appreciating it, but we think it's secondary to shaking. And they came up with what they call the tadpole sign or the lollipop sign for this finding. But we are all agreeing that trauma can set off intracranial thrombosis, and that they may try to say that shaking is a trauma that could do it. The impact is a trauma that could do it. Doesn't have to be a big impact, a trivial impact could do it. Dehydration can do it, infection can do it. Lots of things can set off this kind of process. What I find, but in the Garner case, though, the idea of shaking is supposed to rupture or tear or injure bridging veins. But in the Garner case, we're talking about the dural sinus, which is a big, tough structure that is not going to be in any way damaged by the shaking allegation.
And the scans we're looking at that had the epidural blood, right,
Right.
in Defendants Exhibit 9 and 10, I understand that Dr. Vaslow, the neuroradiologist, said that that can't be caused by shaking.
Correct.
Pass the witness, Your Honor.
I have no further questions for the witness, Judge.
All right, thank you, doctor. You can step
done.
down for now.
Yeah. Let's see if I can get it. Don't up here.
So for live witnesses, that's it for you guys at this
That's right.
point, correct?
Right.
And Mr. Coleman, I know you weren't planning originally until at least tomorrow, half a day. I asked you to see if we could do something earlier. Do you have someone prepared for tomorrow morning?
They'll be your first thing. Well, shouldn't even say first thing tomorrow. They'll be here hopefully tomorrow morning, late in the morning, definitely by the afternoon for sure, Judge. For scheduling purposes, where are we as far as any additional live witnesses later on in the week for the defense?
Your Honor, that's all that we have to present this week, Dr. Delasnik. What, I think I emailed with your coordinator what I propose to do, and I think the courts agreed to this, is save basically, I mean,
Look, and here's the thing. I'm going to give you guys the time you need, depending on what I feel like I need to hear. So obviously you've got some time left today, half a day tomorrow. You've got another witness for sure that you had intended on bringing in person. I'm going to allow that for certain. By the time we get to that, I would think that after I hear the rest of what I hear from the state this week, then when we're finished this week, I may have a better idea of us having a conversation about the affidavits and whether or not I would be okay with just taking the affidavits under consideration, if I would require any of those people to come in person. And so I think we can kind of hit on that Wednesday afternoon, because what I'd like to be able to do between now and when we come back, and I'll talk to you guys about y'all sit down. When we come back, and I have some potential time frame for that also. I've looked at my calendar as well, and obviously Mr. Florence will have to send a request to probably get us some more time. I think we'll still be within the time to get it turned in, but I don't think we'll have enough time to do what we need to after we continue this hearing, if that makes sense.
Still a little confusion. So will there not be any additional live witnesses from the applicant for the rest of the week?
For
If
today.
I could just respond, what I want to do is perhaps call Dr. Delasnik back at the end of the day, Wednesday, after the state's witnesses testify in rebuttal, if I deem that necessary.
Sure.
So a couple hours at the end of the day, Wednesday.
Yeah, and we'll see. And here's the thing: if we get there, let's go off the record for a second. If we run into a time constraint Wednesday and you have some rebuttal, I will allow you time to do that sometime either in between Wednesday and when we come back for the other doctor or at that same time that we set that hearing, if that would work. So we'll try to get it all done this week while he's here.
That's fine, Judge, and just so we can be thinking about it, it would be nice to do some of this by Zoom in the future.
So I don't, this is the type of case where since it's just us, I'm really not opposed to it, honestly. I think it's nice, but I mean, y'all see what I see. Let's talk about that. I think obviously everybody would have to agree. And so if you don't, that's fine. We'll come, but I think it could make it easier for potentially everyone. So I'm not opposed to doing some of this. I don't usually love doing things by Zoom, but with no jury and just us, I think it's something that we could at least take under advisement between now and then. But what I do want to do, and I will let you guys know how I intend to handle some of the affidavits at the end of this week and the testimony, so that between now and when we either come back in person or Zoom or whatever we do, I will know, I'll be taking those into consideration so that once I hear the final evidence, when we come back, I won't have to say, well, I need more time to review all of those. So I'll do some more research, think about that some more, and have an answer for you guys on that. That'll also let you know if you need to bring anybody else, Mr. Udishin, in person, so that when we start coming up with some times to come back, or at least to get all together again, we know if it's for 1 witness, 2 witnesses, 5 witnesses, whatever it may be. I did look, and I want you guys to look at your calendars for possibly the week of, it would be May 12th, which is a Tuesday afternoon through the end of that week, either Wednesday, Thursday, Friday, or Tuesday afternoon, Wednesday, Thursday, Friday. I've got that available. So if you guys can go ahead and start talking to, at least for sure, Mr. Udishin and Ms. Gilbert, if y'all can talk to.
And Your Honor, and I understand this is not your problem, but there's a seminar that's on that Thursday and Friday in Fort Worth that I'm one of the course directors for, that the Innocence Project,
My problem is that what I'm running into is my trial docket.
Yeah.
And
It's just that's kind of a national seminar, and if I miss it, I miss it, but that's something going on that week.
I've got nothing, and I can't, the rest of this month is completely unavailable.
If we could do this on the 12th and 13th, I could get back for that seminar.
So, obviously, if I agree to look at affidavits, that's probably doable. If I don't, it's not. So let's revisit this then at the end of this week, Wednesday afternoon.
Okay.
Judge, I have dates that Dr. Offhoven's available to testify via Zoom, if that's still an option with the court, and I can email those to you. That helps.
Yeah, if you'll look specifically for that week, and even possibly the afternoon of the 11th. I mean, I have dockets. I cannot skip the morning dockets again like I did this week, right? I'd like to not. We could even do Monday afternoon, Tuesday afternoon, and Wednesday, and that would help you, Mr. Udishin, and give us some more time. If you can check with her if she's available on any of those.
Yeah, Your Honor, last I checked with her, she was available on the 11th, so I can think that you're talking about May 11th, correct?
Yes. Now I'm not sure, we'll have to, with regard to the Zoom, and I don't know the current state of the law, honestly, on if there's an objection. I know in trial, if there's a jury, for sure, everyone has to agree. So what I'm going to ask you guys to do is to do a little bit of research on if there's an objection, which I see that there is.
And I don't want to be just unnecessarily difficult. I will concede Dr. Offhoven by Zoom, but Judge, there is something about in-person cross-examination.
No, I don't disagree. I just think because I think obviously in a jury situation, it's a lot different. with me being able to see everyone right here on the screen is just as good as being able to look over here and look over here, in my opinion. But if you will at least, you do not have an objection to Dr.
Under the circumstances with her, the age that's been represented to me and the nature of her injury, I'll make a concession as it relates to her. But just there are a number of issues with the other witness. I mean, I don't know who else is in the room. I don't know what they're looking at. I don't know if anybody's giving signals. Even more than that, just there is just something, there's no stuff.
Well, and we may or may not even get there. So that's going to depend whether or not how I feel about just reviewing affidavits, and legally, if I think I can just review affidavits. I think the law provides for that, and I won't really know how I feel about that until after I hear a little more of what you've got, Mr. Coleman, the rest of the week, and then I know we've got that witness. Let's plan right now then on her the afternoon of May 11th. Now, if it's anything like what we went through today, she's going to need to be available again, potentially the next day though, because we won't get started until 1 o'clock.
She won't be as long.
Okay. Okay. So if we can get through her in that afternoon, then that gives us some more days to still, if I need those days, and I'll let you know, I want this witness, that witness. We'll discuss that.
And Judge, I don't know whether this it makes any difference, but on the witnesses that we're proposing by affidavit, I mean, we're happy to have them in person, but if the court decides it wants to do them by affidavit, if the state wants to send questions to them related to their qualifications, if they want to do that in writing, we would have no objection to like interrogatories related to 702 Daubert kind of issues, if that would make that easier.
Judge, we've already gone down that road and with no success.
Well, this would be just with regard to a potential Daubert hearing, or a Daubert with regard to which I think is really included anyway in all of their CVs. I think, are they all attached or no?
They've all been filed.
Yes.
So,
CVs with everything.
And
so I
Judge,
mean, we've kind of got what they're,
and the subject of their testimony is already, the state already knows because it's in their affidavits. I know the court said you haven't looked at them. I believe they've looked at
I
them.
would think so.
So they know.
So,
what
and
the
who,
subject-
how many are we talking about? Tell me who.
Dr. Vaslow, neuroradiologist, Dr. Monson, who's a biomechanical engineer, excuse me, and then Professor Findlay, who is the law professor
Right.
in Wisconsin. I think that's it, right? That's the three.
And you've got my objection to Attorney Findlay on record.
Professor Finley.
Professor Finley. You got my objection, Judge, on that.
Yeah.
I don't know if he was qualified to give expert testimony in the subject matter in which he's an expert in this particular case.
All right. So here.
And Dr. Vaslow was at it late, Judge. I guess the cure, in all honesty, the cure would be, because we're delaying this, now the state has more time to investigate,
Yeah.
inquire as to Vaslow.
And what I would say is at least, and I'll let you know Wednesday again, because I know you need time to do what you need to do with regard to how I end up ruling on that. But maybe start considering what questions, and if I would allow some general preliminary written interrogatories with regard to what they're testifying regarding, what their history is, some those types of things. And then, but I'm not going to argue about it now, because I'm not saying that's what we're going to do. But we'll know. I'll let you guys know this week.
Are we starting at 9 in the morning?
Well, it sounds like we're not, because but we knew that we were going to be done, and I'd asked you to get somebody here.
Good, Judge. We tried. We just
Okay.
couldn't. They have schedules and there were slides and they had patients. We just couldn't. I'm sorry. We tried.
So I need to know a time to get started then.
They're definitely going to be here by 1 o'clock because that's what we initially set up.
So no one was able to get here earlier.
Well, I've got Dr. Edwards. I could put Dr. Edwards on first thing in the morning. He's out of order. He was going to be my last witness, but if you want to get, I could put Dr. Edwards on first thing in the morning.
You have 4?
Yes, Judge. And they will not be as extensive as this witness today. At least I don't anticipate.
I mean, I don't want, if you feel like there's a purpose and an order, I'm not gonna require that. We can just get started tomorrow at 1 o'clock, I guess.
Can I just inquire, just for planning purposes, what the order is? I know he doesn't have to tell us, but if he would, that would make life easier.
Dr. Yu, Dr. Lindbergh, Dr. Downs, if he gets here in time, I don't know. He's scheduled to come in first thing on Wednesday. I may have to put Dr. Edwards on before I put on Downs, which is probably going to be the case.
Okay, that's fine.
Thank
We
you.
know Dr. Hughes first.
Okay, perfect. Thank you, Mr. Rebuttal.
Is that what we said?
Yeah, let's just do 1 o'clock.
And just to remind the court, I do have an objection on file to Munson and the biomechanical studies. That he's going to testify. Part of my discovery I sent is I simply want to know the data that he's relying on. That's all I need to know. And if he's relying on specific data from this case, the amount of force used, whether or not it was repetitive, that kind of stuff. I mean, I'd like to know. Oh, I can take him on board now.
Well, and Judge, that's all in his report
Well,
already, I
And
think.
if the report is insufficient, then if he's got everything listed in there, that's a whole nother objection I'm gonna have because he does not have enough data to render an opinion in this, or specific data to render an opinion in this case.
I mean, that sounds like, his report lays out his opinion and what it's based on, which is what I believe the state is saying they want to know.
And I'm sure nobody's here locally, but where's Dr. Monson out of?
In Salt Lake City.
Okay.
Or someplace in Utah.
Okay. Okay. All
And
right.
nobody's from Beaumont.
Yeah, we can't just get them over here tomorrow morning and go ahead and take care of that. All right, so we'll get started tomorrow at 1, and I will do some more thinking and research on potentially taking a look at, obviously, once I see something, I can't unsee it, but I almost feel like in order to make certain rulings or to consider whether I need more evidence or to allow cross-examination, maybe I need to go ahead and take a look at the affidavits.
And just on the affidavits, if there are additional affidavits that are filed, the state's concern is, I guess we could do a rebuttal affidavit if there's something in there that I would have preferred to have cross-examined the witness on.
Sure.
And Judge, I'm not going to object to affidavits from the state.
Yeah, I mean,
I believe affidavits are admissible.
Here's what we're not gonna do. Real quick, what we're not gonna do is a response to the affidavit and a response to the response to the response. There's gonna be at some point, we've got the affidavit, a response to it. And then y'all are gonna have to just rely on, hopefully, that I'm smart enough to take all this in and try to figure it out.
Just so we're clear, Judge, we're talking about affidavits from the witnesses that they have listed, right, as expert witnesses, because we've got studies and
The witnesses, the affidavits from witnesses that have been turned over. The only one that I feel like could be an issue would have been Dr. Vaslow. Because now we know we're gonna have some time. I think that cures that issue with regard to him. So it's 3 affidavits that they have provided that probably going to, and also I don't remember how I left it this morning. I'm not going to strike them from the record or try to remove them. I do think that Mr. Udishin's correct. And after talking with Mr. Florence, the court, if I send it up and say I didn't look at it and I didn't let anybody, they're going to say, what is it, and want to see it anyway. So it's going up whether I look at it or not. So I feel like I'm not going to strike them out of the record. It's going to be whether or not I look at them or require them to come in person.
Yes, ma'am. That's with regard to the affidavits. What about the plethora of studies that were filed, that they filed?
And Your Honor, can I say something about that?
Yeah.
All of these cases, including Rourke, including Neves, all of these cases where courts are making these rulings rely upon the scientific and medical literature. And so that's what that is.
I don't think it's crazy for me to put on the record that I'm not going to read 713 pages of literature references from the Finley expert report. I don't have enough time in my day, not doing that. If y'all think something's important for me to see on that, somebody better point out something.
Well, and Judge,
23 pages with regard to that's just exhibits, 387 pages of authority and support of the application for the writ.
And that's what I'm talking.
So that's gonna all go up. It is what it is. I can't, and I'm not going to take the time to go through it and say what is and isn't going to go up. It's filed. That I'm gonna make my recommendation. The Court of Criminal Appeals is gonna agree or disagree with me, whatever it is.
And Judge, those references, well, I know the court's not gonna read them. The reason why we gave them to you is in case you're reading an affidavit and you see one you do want to read. They're hard to find. We want to just.
No,
give it to
and
you
I
in
mean,
case you
it's
need
there if I need it, but just to say I'm gonna sit down and start at page 1 and go through 700 pages of references. But I also am not going to, say that something doesn't go with, if it is something that is discussed in a report and it's a reference with regard to that report or the testimony, then I think the Court of Criminal Appeals gets all that.
Judge, but using Professor Finley as an example, I mean, what if the court makes the decision that he is not qualified to testify in the capacity that he intends to testify? Does his reports or the affidavit?
It's just like in any other trial. I mean, I say something's not admissible and it can still go in for appellate purposes only. So the Court of Appeals in a regular case gets everything. So they either like what I say or they take everything else and do what they want to do with it. That's going to be up to them. But I don't think I stop any of the information from going up there, just like I would in a regular jury trial. Everybody, you get a bill of review, you get whatever you want in a jury trial where whatever information you want them to take into consideration, saying that I made a bad decision, it all gets to go. So I think it all gets to go on this one as well. All right, so I'll see you guys tomorrow at 1. Y'all know I'll be around if there's anything y'all need between now and then. Y'all know how to get in touch with me.
Okay.
All right,
Yes.
thanks. Court's in recess.
All right.